Hey, everybody. Yes, it looks very, very strange this month. It is still Fran McGovern. I am not an air traffic controller now. I did not go as a scab onto the federal, you know, uh, air traffic controller thing when they were all out of work during the government shutdown. I'm actually at Newark Airport in the A gate, so A22 for those of you who want to be specific. Unfortunately, I have to go to a memorial thing in Florida tomorrow morning, so I had to on kind of an unscheduled trip. But I did not want to miss out on First Friday with Fran or seeing all of you. So thank you so much for being here. I hope you all had a great Thanksgiving. I know mine was nice. It was a nice time, and so I'll jump right into it. So please release me, let me go. Right, for those old enough to know, Engelbert Humperdinck made that song famous, and for all those Engelbert Humperdinck fans out there. So we're talking about releases today, but first we'll talk about You Got It, Dog of the Day. I'm sorry about the dorky headphones too; they look really awful. I don't like doing that, but um, so we do have Dog of the Day, very cute dog. This is Sable, and half black lab and half bloodhound. So I imagine if Sable stood up, she probably has kind of stumpy legs. So Sable is owned by April Shower, who is a portfolio manager for RCP Management. For those of you who work with RCP, I try to thank you very much, April, for sending Sable's picture in. As a footnote, the 2026 Dog of the Day calendars are available. So if you're not on the list, please get your name on the list, and we will be mailing out the 2026 Dog of the Day calendars shortly. Also, I forgive all the Taylor managers and board members from Taylor Management that are not with us today on First Friday with Fran. Taylor Management's Christmas party is today, so I hope they're out there having fun. And then we'll jump right into association releases. So releases in association world. Why am I talking about this? People too often end a dispute by just saying, let's sign a release. And a lot of people just sign the form release. Everyone hears the form. You just sign the form. It's the form release. Just sign it. No, release language is very important. So if you're on the association side of things and you're providing a release to somebody, you want to make sure that release is very narrow, right? You want to make sure it's very narrow. If you're an association who is on the receiving side of a release, you want the release to be very broad. So any and all claims from the beginning of Earth to the end of time involving our association, our board members, our management company, our attorney, our employees, our agents, et cetera, et cetera. So if the association is providing the release, narrow. If the association is receiving the release, you want it broad. Is a release really a release in association world? A lot of times it's not, especially in the condo association context. And you say, Fran, then why do we have lawyers spend money on them getting releases in condominiums? The reason I say that is you can get a release in a condominium association for an issue. This usually pertains to water infiltration. But you still have a continuing duty after the release to maintain, repair, and replace the common elements, which would include the roof. So the governing document duty continues even though you're released up to that point. This often happens. Boards will come back and they'll say, Fran, we've had this dispute before. 2 years ago, we had this issue with this lady. She was complaining about water getting into her unit. We fixed the roof and we got a release from her. Why are we even dealing with this again? And the answer to that is the association still has a continuing duty from the time of the release agreement going forward under the governing documents to maintain, repair, and replace the common elements. Okay, that's a nuanced thing. A lot of boards get really frustrated with lawyers when they say, no, we have to deal with her claim again because it's a claim that arose after the release, or that it wasn't addressed as part of the settlement agreement for the release. Mutual and not so mutual releases. From a negotiation standpoint, mutual releases are really compelling, right? That sounds really fair. Let's just have mutual releases. So that's very good from a negotiation standpoint. But again, just don't go with mutual releases. The association, and this comes up all the time in collection cases, right? So a debtor owes the association 15 grand. We go after the debtor. The debtor says, I will pay you 15 grand. but I want a release. We want mutual releases. The association releases me. I release the association, but the association is not always aware of their other claims. So, for example, if you just sign mutual general releases, the homeowner could claim that you released him, for example, for an architectural violation. You see what I'm saying? If there's a deck violation, if there's a maintenance violation, if there's a dryer vent cleaning violation, if there's a parking violation, you could be dealing with a collection issue in a release, but your release is overly broad and it lets other things go. So be very careful, because the discussion topic of let's have mutual releases sounds compelling, but you got to be careful before you get into it. Comprehensive releases. Comprehensive releases. What are comprehensive releases? Generally, they talk about known and unknown claims. What is important in the association world about known and unknown claims? If you're in the position of the association, management or a board member, and somebody you're in a dispute with says, we want you to release known and unknown claims, you have to make darn sure that you have fantastic expert opinions and engineering opinions. Because if you're going to sign off on a release for known and unknown claims, you have to be bulletproof in knowing that there aren't any other issues out there. This comes out often in the construction defect context, where a community has had their clubhouse redone, or it's a brand new community in transition, and there's an issue with the builder, or there's an issue with the contractor, and the contractor says, okay, I'll do all this stuff, or I'll pay you such money, but I want an unconditional release for any and all claims. The problem with that is, unless you have excellent engineering reports and in certain cases have done destructive testing, you will probably be releasing claims that exist, but you don't know exist. Does that make sense? And then what about from the beginning of time to the end of the earth? So in comprehensive leases, the other party often asks for known and unknown claims, and from the beginning of time to the end of the earth. If the association is granting the release, the association would generally try to narrow that and say, no, we're not going to release any all claims because we don't know. So, for example, if a vendor comes on your site and does something bad, we don't want to give them a release that releases anything to the end of time, because they may come and do something else later. And you don't want to give them an argument to say, oh, well, that was encompassed in the release as well. Now, you can litigate that issue, but if you remove it and put an end date on it, we usually put an end date of you're released only with respect to issues that arose up to the time the release was signed by all parties. Okay, so that's the best case scenario. What about parties to release? So as I said before, the association wants a release of the association as a corporate entity. It wants a release of the board members individually. It wants a release of its management team and management company, and any individuals with respect to the association side of things who might be involved. So sometimes that involves committee members, and sometimes association vendors are part of that too. Because as many of you know who are on the call with me today, we've been involved in litigations where they name the association, the individual board members, the management company, the manager, et cetera, on and on. So you want to make sure that if you're negotiating a settlement on the association side of things, you're not settling and only settling on behalf of the association, because virtually all management contracts contain a provision that says the association must indemnify, defend, and hold harmless the management company and the property manager. So if somebody makes a mistake and only releases the association, you're going to have a problem, because the association is still going to be on the hook, perhaps, as the management company will not be released by that release. So be very careful as to the parties for the release. On the association side, you want it to be as comprehensive as possible. If the association is getting the release, if the association is giving the release, you want to limit it to that actual person. What about distribution of insurance proceeds? Distribution of insurance proceeds are generally governed by statutory provisions, right? So an insurance company can't withhold insurance proceeds for a release of issues that are not contained in the claim, right? So you can't extort somebody from the association side of things if the association had coverage and its insurance policy was providing coverage, and say, well, we will give you these insurance proceeds if you sign a comprehensive release. If you don't sign a comprehensive release of any and all claims, we're not going to give you the proceeds. you can get a release and full and final payment language, but only as to the things that are covered for the insurance payment. Does that make some sense, right? But you still want to get that release. I advise all our associations to get that release. There are some issues, nuance. You have to talk to a homeowner's attorney, but you want to get a release and documentation because many times the homeowners, the unit owners, especially in the condo association context, will try to come back to the well again. Okay.
And
Go
Fran,
ahead, Mike. Yeah, yeah,
can I just
sure.
make a quick point on this? So just so everyone knows, this comes up fairly often where you have a loss inside somebody's unit. Let's say whatever, the water heater ruptures. Now you have $30,000 worth of damage. They submit a claim to the association's insurer. Association gets money minus the deductible, and the manager just wants to hand over the check to the owner. And if we find out about it beforehand, we always say, no, 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 slow down. Do not hand the check over until they have signed what Fran just described, that release agreement, so that the homeowner cannot then come after the association for additional proceeds or damages or whatever else. So that's the context where that comes up in our work pretty often.
Yeah, that's right, Mike. And that they probably try to go back to the well 50% of the time. So you got to have that documentation because people will, I hate to say this, but there will be people out there who will try to pimp you even after you've distributed the insurance proceeds. So limited releases. Hey, Harold, you just popped up. What's happening? Uh, limited limited releases. Preserving duties with respect to third parties. This just came up in a case I had with a landscaping slash snow removal company. The association was in a dispute with its landscaping company. They had not performed in the prior season, but they were the snow contractor for like the past 8 or 10 years. And uh, to make them go away, the association negotiated a settlement, and the landscaping company wanted a comprehensive release as to any and all claims. And they said, we'll be really nice to you, Fran McGovern. We'll make it a mutual release. And I said, well, wait a second. If we look at the snow removal contract says the snow removal vendor will indemnify, defend, and hold harmless the association if someone falls in the parking lot during their snow events, right? So we're not going to release you from that. And their statute of limitation for personal injury, bodily injury claims is 2 years in New Jersey, right? So even though this person was fired, the landscaper was fired just now, right? If someone files a bodily injury claim for a slip and fall case, and we had not narrowed that release down, if we had not narrowed that release down, we would not have been able to seek indemnification, defense, and hold harmless from that snow removal vendor, right? So you have to be very, very cautious about preserving duties with respect to third parties, right? Because most association contracts, landscaping contracts, snow removal contracts, roofing contract, construction contracts, contain provisions that if those vendors come on site and hurt a third party, they're going to indemnify, defend, and hold the association harmless with respect to those third party claims. So you have to be very careful about that because if you release it, you're going to be left holding the bag. Um, what about warranties and other rights? Again, you want to carve them out of any release. So, for example, if someone is redoing an indoor pool and a dispute comes up with the vendor who's redoing the indoor pool and you ultimately settle it, you don't want to release warranties and other rights with respect to the equipment that was installed and maybe who was supplied by that vendor. You see what I'm saying? So you want to preserve warranties for the equipment and those other things. What about distribution of insurance proceeds with respect to limited releases? The reason I put this under limited releases is, as I mentioned before, um, you want to be careful and keep in mind that the a release obtained for distribution of insurance proceeds can only apply to the claim itself. You can't extort a person, but by the same token, the association has to be very, very careful with what it signs because a lot of insurance adjusters will send you a check, right? And it will say on their paperwork, this is in full and final payment for the association's claim with respect to X. Okay. And everybody in the world wants a check, right? Of course, right? We love getting checks. And the association's board president or the manager or the management representative will sign it as full and final payment with respect to that insurance company's claim. And they'll cash the check. Okay. Even though the actual claim has not been fully adjusted. The association has other issues out there, and the check should not have been signed for. So, what is the answer there? If it's a significant loss and the association receives a check, especially with correspondence or when the check says full and final payment, make sure you reach out to counsel. Do not cash the check. Hit pause. Hit the pause button because you want to preserve your rights with respect to the association's insurance carrier, and you may have to get additional proceeds under that insurance policy, or you may even have to, God forbid, file a declaratory judgment action to get the insurance proceeds you're entitled to. What is an accord and satisfaction? Why do I have that in here? Accord and satisfaction is not a release, right? But it can turn into a release if you or your lawyer, the association's lawyer, has a dispute with somebody, they refuse to negotiate a settlement, they refuse to sign a release, but you send them a check with a correspondence and marking on the check that this check is provided for full and final payment for any and all claims between the parties. And it's sent to the person who is handling the dispute for your adversary, right? If they accept that and cash that, the vast majority of times, there will be work as an accord and satisfaction of the other party's claims, and they will be stuck with the check that you sent them. Okay. So and this happens a good bit, the benefit of doing an accord and satisfaction check and getting that type of release without a signed release is you're not actually releasing any claims from your side or the association side. If you want to, you can go out and still attempt to pursue that. So that's a kind of a backwards way of doing a release that is more or less a forced release. I've done that various times with construction defect claims because we don't want to get into giving the contractor a release at all. And the contractor, as you might imagine, is very incentivized to cash the check, cash the settlement check, right? But for example, we may not know if they're latent defects. We might not have done destructive testing, but we would like to resolve the dispute as much as possible without releasing any claims. So that was a kind of quick blow through the today's agenda. Any questions out there? I don't see any questions. No, there's one.
Nothing on there yet.
No, nothing out there. It was just too exciting for everyone seeing me in my in my headset and without my tie on. So it's so that's kind of it for today. It was a pretty light one. It's just the thing to do is it's tempting to rush and sign a release. Please don't do that. Please hit pause. Please talk to your attorney before signing a release. And in addition to all those things, since there is no question in the chat, on behalf of Mike, Crystal, Eileen, and everyone at McGovern Legal Services, we want to say Happy Hanukkah and also Merry Christmas. And I guess Happy New Year. I guess I'll see you. I won't see you till 2026, right? Yeah. So, well, it's wonderful. And hopefully I'll come up with a new topic. If anyone has a topic, feel free to email me and we'll jump on that for January. But it's great for seeing everybody. And I appreciate you attending. Have a happy new year. Take care, everyone. All right. Bye-bye.